Muchas gracias. Entonces, buenas tardes.
Well, good afternoon. We've reached a point where we have closing statements, closing arguments, and the respondent has the floor. Thank you very much, Mr. President. Members of the Tribunal, this hearing has confirmed what the respondent has been asserting since the first day of this arbitral proceeding. This tribunal has no jurisdiction to decide on the claims of the claimant under the treaty. And it's good to remind ourselves of what we're discussing in this stage of the procedure. It's precisely the jurisdiction matter. The claimant seems to have forgotten, because 1/3 of its opening statements was dedicated to talking about the merits of this dispute. It can't justify that the text does not say what the claimant wants to say. So the only alternative he has is to distract this tribunal, talking about the ills suffered by the alleged ills suffered by Mr. Lichin, trying to elicit the compassion of this tribunal. Regarding the counsel of the claimant, let me start again. Due to the respect of the counsel of the claimants we decided not to interrupt Mr. Lorenzo while he went through the list of claims that he has against the DR. And if we want to admit this, we would have to say that the claims are right, but we do not say this. We reject this, and we want to reserve our right over the merits of this case. Although we are convinced that we will never reach that stage. We will not go into issues of substance because it's not the moment to do so, but it's imperative to say one thing. The operation of the Duquesa landfill by Lajun, it produced an environmental and health catastrophe in the DR. It has cost the life of several Dominican citizens. It's also important to mention that Mr. Lichin has several businesses in the DR. Several businesses which are different from the line of business of Lajun, and they continue to operate in a normal way, which means that it could not be stated that he does not trust the Republic. The claimant has insisted on the fact that the respondent did not call Mr. Lichin to testify in this hearing. This point was eloquently described, but the merits of the case were not efficiently discussed either, and it's obvious that the respondent did not call upon Mr. Lichin because nothing that Mr. Lichin has to say, absolutely nothing, is relevant for the issue of jurisdiction. It is also important to clarify something regarding the fact that the respondent has not presented factual witnesses in support of its allegations. The claimant attributes a great deal of meaning to that fact, and in its opening allegations, he also stated that it's interesting to note that the respondent, quote, did not find a single expert to support the arguments that it's asking the tribunal to accept. Let us be very clear on this. It's not that we didn't find any experts to support our allegations. It's simply that it was not it didn't look for any experts, because the expertise that they have is also enough to interpret an investment treaty, and this is what the lawyers are doing. The role of an expert is to opine on very high-level areas to fulfill the gaps of knowledge that might be existing in some of these areas. And we trust that the tribunal has enough knowledge. And I think that there's no question on the legal interpretation of an international treaty. This must be objective according to the principles of interpretation of the treaties, which are stated in Vienna II, where the subjective opinion of witnesses are not important in the interpretation of these treaties. In the pleadings and in the opening statements, it was stated that the case of the respondent is only based on the legal arguments of the counsel. It's obvious to say it, but it couldn't be any other way. The role of the counsel is to argue in order to persuade the tribunal that its point is right. Here we are dealing with two merely legal issues. This is why we had a bifurcation, and this is why nothing else is required. Before going into the jurisdictional objections, I would like to point something else out. Our colleague Lorenzo yesterday said he admired the team of Curtis, and I would like to point out that the admiration is mutual. We understand what he said about Silo's advocacy, which he wanted to exemplify with two introductory paragraphs of the respondent. But it's one thing to say that the claim of Mr. Lichin does not have any factual or legal basis, and a very different thing is the interpretation of Mr. Lorenzo, and I quote from the transcript, which means that the claim that Mr. Lichin is a fraud. In other words, we, the counsel of Mr. Lichin, are instruments to perpetuate that fraud. And we believe that what we did in our memorial could be classified as the first example. And if we stated in this way, which didn't happen, it would have been totally inadequate if there are no proofs of a fraud in the claim of Mr. Lichin, and there's no proof that the counsel was a participant in this fraud. It could also be considered Sila's advocacy to say that an argument is completely wrong and to accuse someone of bad faith without any proof. It's curious that after Mr. Lorenzo explained its aggressive litigation style, which must have limits, of course, he accuses us of having hidden the preparatory work or only presenting this work in a partial way. I referred to this in my opening statement, so I will not give further explanations, but I just want to say that the respondent acted diligently to locate these works even after the deadline for presentation of documents, because as we said, we are the most interested party in locating the proceedings for the treaty, which would corroborate what we're saying about the text of the treaty. Let me go into the substance of what we are dealing with in this hearing, the jurisdiction of the tribunal. But before analyzing Article 13, we must begin with a basic premise. Under international law, there is no action which would allow a foreign investor to make a claim directly against the state host of the investment unless the state agrees to do so. To set this in very simple terms, the general rule in international law is the absence of consent to an international tribunal, and consent is the exception and not the rule. If the tribunal reaches the conclusion that there is no consent, as we think it should do, and as a consequence, Mr. Lichin cannot present his claims before this tribunal, there wouldn't be anything unusual in this action. The claimant says that the position of the respondent that we need a separate consent in order to submit the allegation to UNCITRAL. And we quote Mr. Lorenzo's words: the sovereign can always block at the beginning of the arbitration procedure. He also said that we have the keys to the kingdom and we have veto power. Well, yes, this is the case, and there's nothing unusual or unreasonable or unjust in this position. The states, as the DR, have a sovereign prerogative to decide whether or not to arbitrate in investment cases. And in this case, the DR and CARICOM decided, as they had the right to do so, that they did not want to offer a consent to arbitrate these economic cases. So it must be asked, who has the burden of proof to prove whether the state consented to UNCITRAL arbitration, and what is the standard of proof? When we analyze this case, the tribunal must not lose or will not set aside the fact that the article has this alleged consent to an UNCITRAL arbitration, and that this must be demonstrated unequivocally. And even though the claimant and his expert have tried to confuse the standard of proof with other concepts, there is an abundance of jurisprudence by the respondent, which were repeated in the opening statement, and it leaves no doubt that according to international law, the claimant must prove that this consent was given unequivocally and clearly. As we shall show right now, we have a series of tests that were proven, and the respondent has not satisfied the standard of evidence. Let's go now into Article 13 of the treaty. We have repeatedly said that consent for investment arbitration is not an abstract concept, but it refers only to a forum and a set of rules establishing that requirement precisely. During the opening statements of yesterday, Mr. Letley asked, and here I have the transcript, why is it important for consent to allude directly to the rules? I answered that question yesterday, but I want to answer it again because it's a crucial it's of crucial importance in this case. In the words of Mr. Scott Vessel, who we have quoted repeatedly, the consent by the state is specific to the forum and to the party. Therefore, the consent to arbitration according to the rules of UNCITRAL does not constitute a consent to arbitration under exit. And this is very logical because, as we all know, it's not the same, using the example of Mr. Vessel, to have an arbitration according to the Washington Convention and the exit rules, and to have an arbitration according to UNCITRAL. Each of these fora has a defined scope of application, and it has its own rules, and it has to meet these standards. This is why the fora are not interchangeable, and there's no abstract international arbitration. It's also the reason why it's not a mere procedural issue. It's a totally substantive issue. The claimant tries to submit its claims before a tribunal under the UNCITRAL rules, and this tribunal must make sure that there is consent to arbitration according to the UNCITRAL rules. We saw this, and we're going to place it on the screen, that according to Article 1 of the UNCITRAL rules, to have consent to an international arbitration under these rules, it is vital that there's an agreement between the parties to submit their disputes to this type of arbitration. In other words, an alleged generic obligation of submitting disputes to an international arbitration, quote unquote, does not fulfill the requirement of Article 1 of those rules, because the dispute submitted to arbitration must be within the scope of application of that rule. And you have there the scope of application that we're referring to. The claimant is very conscious of this important defect of its argument, and therefore he does not try to talk about the requirement in Article 1 of UNCITRAL rules. The claimant says that the supposed consent by the DR is in the first paragraph of Article 13, but it is not in the second paragraph, which, according to them, it only deals with procedural issues, but not with consent to arbitration. However, Article 1 of the UNCITRAL rules defines the scope of application of the rules, and the essential requirement is to have an agreement between the parties to submit these disputes to arbitration under these rules. This is a substantial consent. It's not a procedural consent. In the case of Metaltech against Uzbekistan, the position of the respondent is supported because the tribunal stressed that it's not possible to have an abstract consent to international arbitration without a forum. The claimant does not like this case, and yesterday they stated that the respondent was referring to the sections of the case discussing the consent of the state to exit in the investment laws of Uzbekistan and not in an investment treaty. But as we said yesterday, that difference is completely irrelevant because the consent of the state to exit arbitration can be found both in a law and in an international treaty. And the general principle of consent to arbitration must be specific to the forum, and this is applicable to both cases equally. In both cases, law or treaty, it is required that this consent be applicable to the case. In trying to distinguish this case, the claimant argued that Article 10 of the Guarantee Law of Uzbekistan was different from Article 13 of the treaty because there is no mention to the exit convention. And here we do have a mention to the UNCITRAL rules. However, the argument by the claimant is not correct because according to that theory, the consent to international arbitration can be found in the first paragraph of Article 13. And in that paragraph, we cannot find any mention to the UNCITRAL rules. These words are not in that paragraph. This is why we allege that this tribunal has no jurisdiction to analyze this dispute. Let us begin by analyzing the text of Article 13 itself. We have said this several times. The claimant says that the first paragraph has the consent of the DR to international arbitration because it uses the word sedan, shall, in English, which means an obligation. Leaving aside the fact that there is no mention to a forum in that first paragraph, which is necessary for a consent, The argument of the respondent fails because shall, in this grammatical context, is being used to indicate something that will happen in the future, which is the way to conjugate the verb ser in Spanish, to be in English. The claimant says that according to Black's Law Dictionary, the word shall is always mandatory, and it only can mean may when it's preceded by the negative no. But this is not what the dictionary states. It only states that shall generally means may when it is preceded by a negative term. It doesn't say that this is the only meaning it can have. It's the only case in which it can be used in this sense. The claimant doesn't like to state that the same dictionary indicates that shall can also be considered as will, which is in point 4 of the dictionary. As Planet Mining against Indonesia point out, Planet and Churchill versus Indonesia, which are cases that yesterday our colleagues tried to distinguish unsuccessfully, as well as several dictionaries and doctrine in this area. The meaning of shall, serán in Spanish, depends on the context, and it not always implies a mandatory character. In its opening statement, the claimant said that in order for the respondent's argument to prevail, and I will quote from the English transcript to be more precise.
Tribunal must accept that shall means may, and that would be in our mindset outlandish.
But that is not the case, as we posit. In order to give to accept the argument of the respondent, we must accept that this refers to something that will happen in the future and not an obligation. So if the first paragraph does not contain an obligation for international arbitration, as stated by the claimant, let me repeat. So if the first paragraph does not contain a consent to international arbitration, as the respondent states, then what does that paragraph say? As we have stated several times, the position of the respondent is that the last phrase of the first paragraph limits to 3 alternatives the resolution of disputes with foreign investors: national tribunals, national arbitration, of international arbitration. So there are 3 alternatives, but it doesn't state how these alternatives are to be implemented. Regarding international arbitration, this implementation is contained in paragraph 2. According to the claimant, the interpretation of the respondent of the first paragraph is left without null and without any effect. So if the first paragraph does not have any consent, it has no meaning according to the claimant. We saw how our colleagues would strike it out of the slide, but this is not what we are alleging. On the contrary, the interpretation of the respondent gives effect to the first paragraph, which comes from its regular meaning. Since we are analyzing the first paragraph of Article 13, I would like to answer the question of Professor FERNÁNDEZ ARROYO posed yesterday regarding this last part of the first paragraph. As we have already explained, the respondent and the claimant have different interpretations on the word serán. The claimant opines that this is a magical word with an obligatory connotation, which indicates the consent of the DR to international arbitration in an abstract sense. The respondent deems that if this word is read in the context of this phrase, it's clear that this is only the future tense of the verb ser. To show that the argument of the claimant is absurd, the respondent decided to take it to extreme, and this is where the doubt by Professor Fernández Arroyo arose. But our point is that the first paragraph does not indicate an obligation, and in any case, the or in between each of these alternatives means that there's no preferred option in this case. According to our reading, there are no added words as the claimant would like to add, such as at the option of the investor. Let's discuss the three possibilities contained in the last phrase of the first paragraph. Since they were stated yesterday when answering the questions of the members of the tribunal and this morning in the exposition. We will be brief because in this discussion, what we are referring to is the alternative of international arbitration, and the entire argument by both parties has centered in this issue and not on the other options. In spite of being repetitive, let's underscore that the position of the respondent is that the word serán in the first paragraph does not mean an obligation and does not indicate a consent. Its implementation is ruled by paragraph 2, whereas the implementation for national tribunals would be under national law, and for national arbitration, it would be ruled by national arbitration. Our colleague Lorenzo said that he didn't know that if the state would veto in national tribunals. In order not to have confusion, there's no defense of sovereign immunity by the state before its own tribunals. It's clear that this is not an impediment, and national tribunals are open and are also independent to decide on any type of dispute, including the disputes that could exist in this case regarding the concession contract. Now, let's go to the analysis of paragraph 2. An important part of the interpretation theory of the claimant has to do with the introductory phrase of the second paragraph, which simply states when the controversy is referred to international arbitration. To the claimant, this phrase confirms that there's an open offer of consent to international arbitration on the part of the DR, because it shows that there is already an arbitration. It already occurred. It already began. As we explained several times, this cannot be the meaning of the first sentence for several reasons. First of all, because the first paragraph does not contain consent, and to that extent, there is nothing to be confirmed. And second, because there's nothing like submitting an international arbitration in an abstract sense. And third, because if the introductory phrase contained there were to have...
Three, because if the introductory phrase that would have the meaning assigned by the claimant, it would be written in a different verbal tense. And 4, even more important, because the next sentence requires the parties to reach a separate agreement ex post in order to remit a given controversy to international arbitration under UNCITRAL. The next sentence actually says the investor and the party involved in the dispute may agree to refer it to an international arbiter or to an ad hoc arbitration tribunal to be appointed according to special agreement or established pursuant to the under the UNCITRAL arbitration rules. Now, let's go through this in parts. I'll try and be clear in my explanation. And I'm still on the second paragraph. I will be referring, and I please ask you to pay attention to this, to the words may agree. The manner in which we read, and we believe this is the correct way to understand paragraph 2 of Article 13, is that they may agree applies both to the international arbitrator or to the ad hoc arbitration tribunal that may be appointed by a special agreement. But they may agree also applies to the second portion of this sentence, and this is the one referring to the UNCITRAL rules. This is the only way that one can give effet utile to the word or. In other words, it is applicable to both portions of the paragraph. So, therefore, our understanding is that paragraph 2 provides an option for parties to reach a substantive agreement to refer the dispute to the UNCITRAL rules or others. But it means that there needs to be a later agreement in order to reach this substantive consent by the parties. As Professor Cohen clearly indicated during yesterday's opening allegations, if there is a possibility for parties to agree, we've got the may agree terms, there's also the possibility that perhaps the parties may not agree or may disagree. And that, members of the tribunal, is where the interpretive theory of the claimant collapses, because if there is no agreement to an UNCITRAL arbitration, this tribunal does not have jurisdiction. Now, claimant alleges that, or avers that in the case of disagreement on one or the other matter, then the option by default provided by the second paragraph is what the claimant says applies. But we have all now seen that that option does not exist. In order for there to be a true default option, it suffices to look at the dispute settlement clause of the claimant's favorite case, and I'm referring to the Garanti Cosa case. In Article 8 of the UK Turkmenistan bit, there is a true option by default, and it's expressed, and it does refer to the UNCITRAL arbitration. We can see this in the last portion of paragraph 2 of that article. And yesterday we also spoke about the existence of other treaties that have a similar clause, and quite clearly they do apply a default system. The claimant bases its particular interpretation of the second paragraph on the famous comma of the Spanish version of the treaty. And yesterday we already spoke about this. This is a very versatile comma because it, according to the claimant, has two purposes. The first function of the comma, according to claimant, is to ensure that the phrase may agree is not applicable to the second conjunction or, between a special agreement or UNCITRAL rules, but only to the first, or between international arbitrator or ad hoc arbitration tribunal. The comma would act as a kind of barrier, or perhaps like a kind of full stop, ensuring that may agree then does not agree to the latter part of the sentence, and therefore that last portion, or that that last conjunction, is left hanging without having a verb. The second function of the comma, according to claimant, although I must admit, as I said yesterday also, I'm not quite clear if we're referring to the same comma, or if the comma has shifted, or if it's a new comma. But in any event, it means that the second theory of the claimant is that the comma separates out the words if there is no special agreement. So this means that the UNCITRAL rules will be applied by default if the parties do not reach any special agreement. Let us move on. Quite honestly, we do not understand how the claimant and the expert emphasize this comma so much, one that does not appear in the English version. It is a basic principle of interpretation of a treaty that a provision that has been drafted in two languages and that has two authentic versions, as in this case, has to be interpreted in such a manner as to reconcile the two versions, thus avoiding a conflict. The interpretation put forward by claimant cannot be supported in the English version, and let us recall, it is the version in which the draft of Article 13 of CARICOM was drafted. In any event, there's absolutely no doubt, even in the Spanish version, that the phrase may agree is applicable to the first conjunction in the sentence, and that the comma cannot magically turn the UNCITRAL rules into the default option. And lastly, the famous comma that appears only in one of the versions of the treaty does not have the effect nor the importance that the claimant assigns to it. It is simply there in the Spanish version in order to establish a pause, because the text in Spanish is longer than the English text and indicates that what comes before applies to what comes afterwards, and to what comes afterwards in its totality. Without having that default option that the claimant tries to build through the comma and other arguments, the claimant's interpretation cannot be supported neither logically, grammatically, or legally. Not finding consent to the UNCITRAL arbitration in the very text of Article 13 of the treaty, the claimant then points towards the correspondence exchanged by the parties as source of the consent. According to the claimant, it is in that exchange of correspondence between the parties that the parties came to agreement on the application of the UNCITRAL rules, and this is the alleged default option, as we've already seen. But in that exchange, there is no consent from the Republic to refer disputes between Lichin and the UNCITRAL arbitration. As the claimant's expert recognized, participation by claimant in the constitution of the tribunal and its agreement to the UNCITRAL rules is for procedural effects and cannot be considered as accepting the jurisdiction of this tribunal, nor substantive consent to UNCITRAL arbitration, as we've already seen in the first article. Even less can that correspondence be relevant And it's for the following reason. From the very first communication dated 16 March 2018, responding to the notification of the dispute by claimant, the respondent reserved all of it, made a reservation as to all of its rights and continued doing so in all following communications. In the slides you have before you, and we will be shown them, there are several, and you will be receiving a copy of this presentation. You will see that we have highlighted the reservations as to rights in the different communications sent by respondent to claimant. And these are all the communications exchanged between the parties. As you may note, it is false for the claimant to assert in its opening remarks in response to a question by Professor Leithley that the first time that the state reserved its right with regards to objections to jurisdiction was through an email dated 11 June 2018. As of 16 March 2018, the respondent had already made a broad reservation as to rights. Mr. Leithley then had a follow-up question for Mr. Lorenzo, and I quote, "What would you think a state will do when there is an arbitration notification that does not have the effect of giving the consent that you say was given in paragraph 2? Mr. Leithley himself explained his doubt, indicating, and once again I quote, "There might be some kind of dilemma for the state in one of the interpretation, because if that request for arbitration doesn't receive a response, as a state one doesn't want to do anything, the state is at a crossroads that they don't need to respond at all, and that could be serious. Or on the other hand, the state could respond as it did, but then immediately, based on your interpretation of paragraph 2, that could be considered somewhat unfair for the state, could be counterproductive as to their desire to find a forum for arbitration." So that was a discussion we heard yesterday. The answer is that that correspondence has as purpose to reserve substantive objections and exercise a merely procedural right. Mr. Lorenzo basically responded with similar words that broad reservations of rights by the respondent weren't sufficient, and if the respondent didn't want to give its supposed consent to the uncitral arbitration, in essence what it should have done is put forward its jurisdictional objections. That is implicitly what Mr. Lorenzo was stating here. And this, of course, quite respectfully, is absurd. A broad reservation, members of the tribunal, is a broad reservation, and the respondent had no reason why it had to put forward its jurisdictional position at that point in time with regards to the case. Lastly, let us look at the text of the third paragraph of Article 13, to which the claimant attaches so much importance. The claimant emphasized in its opening comments yesterday that the third paragraph of Article 13 of the treaty supported its position, and that the respondent didn't even mention it in their opening statement. And it's true, we didn't mention it for a simple reason. It's absolutely irrelevant in interpretation of the two first paragraphs of Article 13 of the treaty. The third paragraph simply establishes that if there is consent to international arbitration, obviously referring to a perfected consent, it is not possible to refer to diplomatic protection for the investor. The best example to prove this is the TLC between CARICOM, the FTA between CARICOM and Cuba that was signed shortly after this treaty. As we see on this slide, Article 12 of the chapter on investments in that treaty, although clearly there is no consent to arbitration in the first paragraph of that provision, because it simply says that any one of the parties may submit a dispute to the tribunals of said party or national or international arbitration. But despite that, despite those words in the first paragraph, the third paragraph of the provision contains an identical provision to the third paragraph of the treaty. And the third paragraph does not magically create consent to uncitral arbitration that does not exist in the two preceding paragraphs. As the very language of Article 13 doesn't help the claimant resorts to all kinds of extra-textual recourses to support its position. In other words, the claimant pointed out that the purpose and goal of Article 13 of the treaty must necessarily be the granting of broad consent to international arbitration due to the fact that in approval of the treaty by the Senate of the Dominican Republic, it was indicated that the increase in investment between the signatory parties requires, and I quote, a legal, judicial, and regulatory framework to promote and protect investments. Although this has no relevance for the effects of a determination of the purpose and intent of the Article 13 of the treaty, incredibly, the claimant, responding to a question by the tribunal, felt that the word judicial includes international arbitration, which is not logically grounded and even less any legal or grammatical merit. This seems to relate to the internal resources available within each one of the parties, that each one of the signatory parties to the treaty, in keeping with what is provided in Article 8 of the treaty, and to which the ones who wrote about the treaty made reference, believing that the investors have internal resources to resolve or settle their disputes, but not consent to international arbitration. That is the true interpretation that should be given to those words within that document of the Dominican Republic. Furthermore, claimant continues betting on the alleged similarity of this case with the Garanti Cosa versus Turkmenistan case. But although we consider the decision of the majority in that case is mistaken, and we have already said it, and I believe we've also proven it, and therefore, precisely because it is erroneous, it was criticized strongly both by the dissident arbitrator and by the doctrine. Article 13 in the treaty is quite different, both in language and structure, to the provision on dispute solution settlement in that case. And we referred to our explanation yesterday. Basically, we have shown you this slide showing the text of Article 8 and Article 13 of the treaty to prove that there is a difference in language and structure. The claimant tries to remove relevance from the dissident opinion in Garanti Cosa because it was issued by, they said, the arbitrator appointed by Curtis. However, the opinion of Professor Laurence Boisson de Chauzerne, a well-known professor in international law, is also shared by Professor Gassini, for example, somebody we don't even know, actually. Let us recall what Professor Gassini said, and you have it on the screen right now. And the Garanti Cosa clause is totally different from Article 13. The reasoning of that majority is erroneous, and not only for the Curtis Council. The claimant practically spent no time during the opening presentation with regards to the argument of the most favored nation. We believe they realized that it made no sense to insist on this and its application because its alleged function as a confirmation method has no background nor any legal underpinning, as we demonstrated yesterday. Lastly, the claimant resorts to the testimony of two witnesses who allegedly participated in the negotiation of the treaty, plus an expert in support of the interpretation. You spent a lot of time on this yesterday. Let me make a very brief comment with regards to Mr. Emanzabe. In his statement, the claimant expressed it incredible that the Republic should have requested an elimination of the testimony provided by Mr. Emanzade in the binder because of his non-appearance in this hearing. However, what is incredible is that Mr. Imamzadeh, after having presented the preparatory work of the treaty and that he himself participated in the drafting and signing of the free trade agreement with Central America, whose dispute settlement language is totally opposite and was negotiated by the same team simultaneously, did not present a witness statement together with the rejoinder by the claimant, and didn't want to be cross-examined by the respondent in this hearing, alleging political reasons that have nothing to do with the case. The testimony provided by Mr. Hilton doesn't contribute either in any way whatsoever to the claimant's case, despite the lack of relevance of the alleged intentions of the contracting parties in interpreting the treaties according to the Vienna Convention. What was obviously from the examination of Mr. Hilton is that the interpretation he made after being contacted by telephone by Mr. Lichin for the case is exclusively based on his own reading of the text of Article 13 of the treaty, more than 20 years after the relevant events, and without any documentary support that was contemporaneous to support him. The phrase, and we will recall Mr. Hilton on this basis, is "I can't recall," or similar expressions that he used about 30 times during his examination. It is truly surprising that a witness who basically can recall nothing with regard to anything about the trade treaties he negotiated at the time or any of the meetings to negotiate said treaties should recall with such clarity a very specific provision such as Article 13 in this treaty, and that he didn't even try or attempt to incorporate in his profile as an important milestone in his career until this case began. In effect, what came out through the examination of Mr. Hilton is that he did not participate at any of the meetings in which the text of the treaty was discussed, and even less the meetings that discussed the dispute settlement methods in the drafts of the current Article 13, and this is what he confirmed to Professor Cohen. Supposedly, Mr. Hilton attended other high-level meetings of which there is no record and where not even he can recall what was discussed. Although Mr. Hilton said in his second witness statement that he was at the head of trade policy in Jamaica at the national level during the negotiation of the Dominican Republic CARICOM Treaty, and that he was leader at the bilateral ministerial level of negotiations with Jamaica as Minister for Foreign Trade, he needed to amend or correct his statement because he didn't have that position at the relevant time. Mr. Hilton tried to provide and explain, saying that the error was irrelevant because in any event, he was working as a Minister of State within the Foreign Ministry at the time. That was his response. However, as we can see in his very profile, his chief function as Minister of State at the Ministry of Foreign Affairs was to chair the Committee on Policy Management for the Ocean and Coastal Area of Jamaica. This has nothing to do with the negotiation of trade agreements. And as Mr. Hilton himself confirmed in the hearing, State Minister is not part of the cabinet. Therefore, it's not easy to believe that from that position he could have been leading the trade policy for Jamaica as he now says he was doing. Neither could he explain why he didn't include negotiation of the treaty in the detailed profile that he submitted to his political party when providing his candidacy to be the chairman of his party. And this is even more interesting. Despite having included the negotiations of all the other free trade treaties or agreements negotiated by CARICOM at the time, I'm referring to the treaties with Venezuela, Colombia, and Cuba, it's interesting to see that even in the case of Venezuela and Colombia negotiations where he did participate, according to his profile, and his CV that he did submit for this case. And he also mentions as important milestones in his career, he couldn't recall something as basic as these treaties not having chapters or annexes on investment, and even less the dispute settlement methods between investor and state. Neither did he seem to recall much with the FTA as to the FTA between CARICOM and Cuba at the same time, although he also includes it in his profile and CV. And this he also mentioned as an important milestone in his profession. In other words, Mr. Hilton recalls absolutely nothing with regards to negotiation of trade agreements that he did include in his profile and CV, and the only trade agreement for CARICOM that he didn't include, and that allegedly he forgot to include it, is the treaty that is the matter of this case, with over 100 provisions. But for these, he does perfectly recall the dispute settlement mechanisms in one of its annexes. Quite respectfully, this lacks entirely any level of credibility. Let us look at what we heard this morning from Professor Paulin, a specialist in international trade, but not in the writer of international investments. Quite respectfully, appeared to be a true contortionist. When it was obvious that his theory didn't work, he always had an alternative theory to prove to some way that there was consent to uncitral arbitration in the rules. So first, he said that Article 13 contains that consent, to then say that the consent is in the provision, adding the prior correspondence of the correspondence prior to constitution of the arbitration tribunal, saying that it is in the text, reading it with application of the most favored nation clause as a mean to consent to that. What we see from the examination of Mr. Paulin is that for him the consent of the Republic's arbitration to uncitral is like a jigsaw, and you need to look for the pieces in different parts, but even with all of that it's impossible to build a jigsaw. The professor said that the two paragraphs of Article 13 must be read consecutively, and there's a logical sequence between both to come to the conclusion that there is consent to uncitral arbitration. Quite obviously, he no longer considered that paragraph 2 is unlinked or delinked from the first. The expert also confirmed that, curiously, the claimant did not ask him to present a new legal expert after the respondent had submitted a broad reply. It's not quite clear what the reason for these decisions when the prior memorials copied verbatim the arguments of Professor Paulin. As a consequence, Professor Paulin did not refute the arguments put forward by the respondent. In a moment of the cross-examination, the expert confirmed that, differently to this treaty, the alternate model bit of the United Kingdom does have an option by default to uncitral rules. Professor Paulin also had to admit that consent to international arbitration under uncitral rules is a substantive requirement to be complied with in order to be within the ambit of the scope of application of the uncitral rules. It's not merely a procedural matter. He also referred to the model clause of uncitral, but from the exchange with the president, what came clear, the president of the tribunal I'm referring to, is that he was unable to identify a consent in accordance with Article 1 of the treaty. In conclusion, it is interesting to note that the example of the insurance that Professor Paulin seemed to like so much doesn't help him either. The professor compared the investor to the person insured, but the fact is that investment tribunals have consistently confirmed that investment treaties do not work as insurance policies for investors.
As to our objection in terms of indirect investors and indirect investments, we're going to invite the tribunal to refer to what we expressed in our opening statement. We do not believe that the claimant said anything new. What we saw in yesterday's presentation is that they only attacked the line of cases where they participated as lawyers without rebutting the juridical points or submitting their legal arguments. In conclusion, through all of the jurisdictional objections here submitted, the tribunal does not have jurisdiction to receive the case. So we request that the tribunal reject the claims of the claimant because of lack of jurisdiction, and that he should be made to pay all the costs of this procedure, including legal fees and the representation expenses of respondent. Thank you very much for your time. We are going to have a 15-minute break, and then we will hear the closing arguments of claimant.